12 Angry Men.
You've listened to a long and complex case, murder in the first degree. A premeditated murder is the most serious charge tried in our criminal courts. You've listened to the testimony. You've had the law read to you and interpreted as it applies in this case. It's now your duty to sit down and try and separate the facts from the fancy.
So many of you have probably seen this movie, classic legal film, 12 Angry Men. Of course, you notice only men on the jury, old film, doesn't go that way anymore. And what the judge is doing here is giving jury instructions, which quite frankly can be very boring. But at the end of a trial, and sometimes in the beginning of the trial as well, the judge is giving out jury instructions to tell the jury what their job is and how they do that job. And it's actually very important because that's the law part. Whether the jurors actually pay attention or not, one never knows. But let's see what the judge has to say here.
One man is dead. Another man's life is at stake. If there's a reasonable doubt in your minds as to the guilt of the accused, a reasonable doubt, then you must bring me a verdict of not guilty. Now, if, however, there's no reasonable doubt, then you must, in good conscience, find the accused guilty. However you decide, your verdict must be unanimous. In the event that you find the accused guilty, the bench will not entertain a recommendation for mercy. The death sentence is mandatory in this case. You're faced with a grave responsibility. Thank you, gentlemen.
The alternate jurors are excused.
So alternate jurors, you have those on a jury in case you lose a juror during the trial and you want to keep going. Sometimes the alternates get to deliberate, sometimes they don't get to deliberate and participate. It's usually by an agreement of the parties, but having alternates is very common. You also heard the judge talk about reasonable doubt. That's the criminal standard. So if you're charged with a crime, you gotta be found guilty beyond a reasonable doubt. What a lot of people don't know is that's not the standard that you see in a civil case. So in a civil case, like a car accident case, the plaintiff, the person that got injured, their burden of proof is what we call it, is what we call the preponderance of the evidence. Well, what the heck does that mean? What that means is more likely than not. Well, what the heck does that mean? Well, that's what the attorneys are explaining to juries in trials, and there's a few ways of explaining it. Some people like the football analogy, where preponderance of the evidence means you got the nose of that football just past the 50-yard line. Other attorneys might say it's a paper-thin margin by having two equal stacks of paper and taking one piece from one stack, putting it on the other, tips the scales, right? That's preponderance of the evidence. So a lot of people get that confused, but two very, very different standards. The criminal one, much, much harder to meet than the civil one, and that's important if you're trying a case.
The jury will now retire.
Judge looks a little tired. And there he sits. You notice how a few of the jurors looked at him when they were walking away? A bunch of lawyers might tell you different things about what that means, but generally speaking, in lawyer land, if the jury looks at you, it's usually a good thing. Not always, and it's really, really tricky to start adopting those kinds of rules, but it can be a good thing. And so, well, those of you that have seen this movie, you know how it turns out. Those of you that haven't, you really should see it. And don't go watch the new version with Tony Danza. Watch this one, it's way better.